African Labor Law Society. And then I'll introduce our other speakers.
Okay, thank you very much, Tequila. And I'd like to extend my warm thanks to President of the DC chapter of Lera, David Jacobs. And I would just like to salute my colleagues and comrades. Thank you very much for this opportunity to be here and to just share about the African Labor Law Society. And I think it may sound strange in America where, you have large national and regional state associations dealing with issues of labor law. It's not the same in Africa. We have an African Labor Law Society really because we've realized that African labor lawyers are not very well organized and we haven't been having conversations around labor law. So at the 2015 Lera, so the International Labor and Employment Relations Association Congress, which was held in Cape Town, about the non-representation of African labor law and labor lawyers and scholars within international and global debates on labor law came to light, and there was a decision to establish a society, and that is the reason why the African Labor Law Society exists. There are not many national associations of labor lawyers in Africa. We have the South African Society for Labor Law, which was helping us to found our society. But other than that, we've been able to establish one in Lesotho and in other countries where they're coming up in Kenya, Tanzania, as well as Botswana. So for us, it's important to come to a space where we can engage debate and come up with our ideas and our theories and our practices around labor law based on the African context, and also to share our experiences and our knowledge. So it's a privilege really and an honor for Homotso to be here to present the perspective of racism in Africa. Racism, I think, is an issue that touches us all across the globe, in societies and in the workplace. And it's something where we can contribute and share our perspectives and our experiences and also learn from you. So we're really, really grateful for this opportunity, and we hope for future engagement around this. Before I finish off quickly, I'd just like to share with you our flyer for the, I don't know if you can see this. For the next conference that we are going to hold. It's going to be in Mauritius. So this is the 5th Annual Labor Law Society Conference, and we shall have it on the 29th and 30th of March 2023. We invite you to join us, and it's really talking about labor law in Africa in a global tech era. And for some reason, I'm not able to move the slide. I just wanted to share a few pictures from previous conferences just to give you an idea of the collegiality, the interaction, the engagement. There's so much that will be happening there. And we invite not only scholars in Africa, but even scholars from abroad who have perspectives and have ideas that are relevant to Africa, that are relevant to the labor market, contemporary labor issues, to share your perspectives and to join the debate. And we hope for more future interaction with your society and with other societies within the Americas. Thank you very much for this opportunity, and we look forward to this debate on a very, very relevant and topical issue.
Thank you, David, and thank you, Pamitai, for those excellent introductions. I'd also like to highlight Human Hedayati. He works with the Communication Workers Union, and he's our contact at the American Constitution Society DC Lawyers Chapter, another of our co-sponsors. We are extremely fortunate that today's speakers have agreed to participate in DC Lera's Labor Law Forum. For the next hour and a half, they are going to take us on a journey through time and space to discuss the construction and deconstruction of racism at work and in society We'll start out in 17th century or 18th century colonial Virginia, and we'll move to the mid-century civil rights era and to modern day Roma using civil rights era techniques to improve their lot in life in Eastern Europe. Then we'll move to the modern day, and we'll have Komozo Mufamadi and Rebecca Dixon discuss modern issues, the legacy of the construction of racism and existing issues in the continual struggle to deconstruct racism in the workplace and society. I'm going to briefly introduce our speakers, and then we really look forward to hearing from them. So Randy McLaughlin is of counsel with Newman, Ferrara, LLP, and professor of law with at Pace University in New York. After graduating from Columbia and receiving his law degree from Harvard Law School, Randy has spent his career litigating to redress incidents of racially motivated violence and securing voting rights for the excluded. As a law professor, he continues to litigate and involve his students in civil rights cases. After Randy, we're going to hear from Sunny Rucker-Chain, Dr. Sunny Rucker-Chain. She was recently appointed as associate professor in the departments of Slavic and Eastern European languages and African American studies at Ohio State University. She is author of the book Roma Rights and Civil Rights, a transatlantic comparison. She also serves as co-director of the Howard University undergraduate think tank. She received her PhD from Ohio State University. Next, we're going to hear from Komozo Mufamadi, a law lecturer at the University of Johannesburg in South Africa. She received her bachelor's and master's of law from the University of Witwatersrand, and she served as law clerk for several South African Supreme Court justices. She is CEO and director of business development of Spread Love Movement, a nonprofit focused on effective career guidance at under-resourced schools. Finally, we'll hear from Rebecca Dixon, who lives in Washington, D.C. She is executive director of the National Employment Law Project. She is a respected national leader in federal worker rights advocacy and provides thought leadership on labor, racial, gender, and economic justice. Rebecca received her bachelor's and master's degrees in English from Duke University and her law degree from Duke Law School. As the descendant of the enslaved people and daughter of sharecroppers and domestic workers, Rebecca knows firsthand what is lost when workers of color are relegated to the lowest rungs of our labor market without respect, rights, or protection. So thank you all for coming to speak with us. We're really looking forward to hearing from you. And now we'll turn it over to Randy.
Thank you so much. So my topic is comes out of an article that I wrote on the title of the article is The Birth of a Nation, a Study of Slavery in 17th Century Virginia. As many of you know, the first Africans in the Western Hemisphere, at least in North America, landed in 1619 in August in Jamestown, Virginia. Now the question emerges, what was the status of these Africans? Who were they? Where did they come from? Did slavery even exist in Virginia in 1619? It did not. In fact, if you look, and I have, at the official records of the colony, there were 20 Africans who were taken off the ship. Where did they come from? The English were basically pirates. They would go out and steal gold or whatever they wanted because the Spanish colonialists would gather gold and silver and whatever else they could find in the Caribbean and take it back to Spain. So on this particular occasion, 2 ships went out to maraud and rob and steal and be pirates, but there was no gold. There were only 20 Africans, well, actually more than 20 Africans, only 20 survived the journey back to Virginia. But there were no plans for these people. So was there a system of labor in place in Virginia then? Yes. They would import, I use that word, whites, Irish, lower class English into the colony as indentured servants. You worked for a period of years and then you were freed and you could go off and get your own land, et cetera, et cetera. From 1632 to 1661, in the county records in Virginia, there were listings for Negroes, Negro servants. The word slave did not exist anywhere in the laws of Virginia. There's no listings. That didn't happen. The first court case, so what happened to these folks? They were placed in a form of indentured servitude. They had to work longer years than the whites did, but they were free. They were free and actually owned property, imported servants, just like the whites indentured servants. The first court case, 1625, dealing with the status of an African who was seized, another African seized from a Spanish ship. Now, what the Spaniards did when they were sending Africans over from Spain, they would have some priest baptize the Africans, so they were now quote unquote Christians. They didn't want infidels coming to the Western Hemisphere. So in this particular case, 1625, a Portuguese sailor sued in the general court for lost wages. The court was also to determine who had the right to the labor of this African. His name was Brazé. The court ruled that Brazé was to work for the colony, and the Portuguese sailor would be paid from Brazé's wages. Brazé was to work for Lady Yardley, one of the royalties, if you will, in the island, in the colony, and was to be paid 40 pounds of tobacco for each month of his labor. You don't pay slaves. That's impossible. Of course not. So he was clearly not a slave. Here's another case, 1630. This is the first mention of a Black person reported in the judicial proceedings of the governor and council of Virginia. Quote, Hugh Davis, a white, is to be soundly whipped before an assembly of Negroes and others for abusing himself to the dishonor of God and the shame of Christians by defiling his body and lying with a Negro. So here you had a white person tied to the whipping post and whipped in front of Blacks. That would not happen anymore after that. Second case, so the first period is 1619 to 1640. That's at the beginning period, and you're starting to see Africans going into courts and getting freed when they were unlawfully held. The transition years between servants, slavery, or both was 1640 to 1660. In 1640, we have the second case of an African and a white having interracial sexual relations, but the punishment flipped. Here, Robert Sweet, a white man, was charged with impregnating a Black servant, not slave. Sweet was to do penance for his offense at a local church. The Black woman was tied to the whipping post and whipped. She was pregnant at the time. So a few years later, after Hugh Davis was whipped, 10 years, now we're whipping Black women for engaging in the same behavior, whereas the white gets a slap on the wrist. You're starting to see racism creeping into the law. 1640, here's a great case, John Punch. Some of you may have heard of John Punch, maybe some of you haven't. Now, according to Ancestry.com, I'm not saying this, Ancestry says it. John Punch is directly related to Barack Obama. Wait a minute, I thought he didn't have any Black folks in this country. I thought the only Africans he had in his line came from Africa, directly, Kenya, exactly. No, John Punch, according to Ancestry, had blood DNA with Barack Obama's mother. Yes, Punch was a mulatto. And well, we'll see what happens to John Punch. Case of John Punch. Three servants of Hugh Gwynn had escaped and were captured. The two white servants were sentenced to 30 lashes and had an additional year added to their service. They were servants. Punch, the African, was sentenced to serve for his natural life as a slave. First court reference of slavery, Now, you can't sentence someone to slavery if they were already a slave. So by definition, John Punch was a servant before he was a slave. First case. Here's a fascinating case. 1653, we're still in this transition period. As you can see, both things are happening. Anthony Johnson in Northampton County. Who was he? He was an African, former indentured servant, served his period of years and was freed, and then got land. He actually owned, at the time, 250 acres in that area in Northampton County. He had a Black servant. He actually had not just Black servants, he had white servants also from Ireland and lower class English. But this particular fellow, John Casser, he contended that he was only a servant and could not be held as a slave. That's what he said. Johnson believed Casser was a slave. And two whites came to Johnson's property and said, you can't hold this guy as a slave. You're going to get sued. And so Johnson let the guy go. But then he thought better of it and said, no, 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 you can't take my slave. And Johnson, the Black man, went to court to get against the two whites who took Casser to get a decision whether or not Casser was a slave. And in fact, Johnson won. It's the first court case where a servant claimed to be a servant was found to be a slave. First time. Now, in this case, which we'd never see in the future, Blacks couldn't sue whites in Virginia or anywhere else during slavery times. Not only did he win the case, but the whites were ordered, two whites, to pay the costs of the litigation. Another fascinating case, 1653, it's the exact opposite of Johnson. This is the case of Elizabeth Key. Fascinating story. She sued in the Virginia courts for her freedom. She claimed that she could not be held as a slave because she was a Christian, and Christians could not hold other Christians as slaves. That was English common law. She also argued that she could not be held as a slave because her father, English, was a free man. Again, your status in England, English common law, followed the status of your father. Both of these arguments would later be unavailable to any Africans, but they were available to Ms. Key. The court ordered Ms. Key freed based on these two arguments. The last record of Ms. Key was her marriage certificate to one of her lawyers, a man named William Greenstead. I dare say it was not likely that Mr. Greenstead was Black, given the fact that he was a lawyer, and I can't imagine, though I have no proof of this, but it's unlikely in my mind that he was an African at that time. So what does that tell you? Interracial marriage was not illegal in 1653. All right, what happens after this? I think the most, and I've got a lot I could do, but I don't want to run over my time. The first slave code was passed in 1680, the real first slave code. What had happened before that time? In 1676, Bacon's Rebellion happened. What was that? Bacon was a general, military fellow, and he formed a coalition of freed indentured servants and Africans to rebel against the colonial governor and burned Jamestown to the ground and took over the colony. And for a period of time, not too long, because the British came with more troops, they created the first interracial society without slavery and worked together without any difficulties. But the British came. But this was the first insurrection against servitude, and it taught the planters a valuable lesson, that whites and Blacks were uniting against their common oppressor. After Bacon's Rebellion, the status of Africans as slaves became more commonplace, whereas the protections of whites through newly adopted laws began to separate workers along race lines. 1680, first slave code. 1, illegal for Blacks to carry weapons. 2, illegal for a Black to leave the property of their master without papers. You get 20 lashes for that. 3, if a Black person raised up his hand against a white, for every offense, 30 lashes. 3rd or 4th, if a Black escaped and resisted capture, it was legal for a slave catcher to dismember that person or kill them outright. 1682, laws changing again. General Assembly passes a law. All Blacks who entered the colony would be held as slaves. No more servants, all Blacks, unless their native country was Christian. The only Blacks who would fall into that category would be Ethiopians, because the Ethiopians were Coptic Christians, but we weren't getting anybody from Ethiopia. They were coming from West Africa. And there were Muslims, yes, and there were traditionalists, but there were no Christians, not in West Africa at that time. So basically, no Black could be anything other than a slave. And in 1682, Africans were precluded from entering courts to seek their freedom. 1691, first, if a white married a Black, they would be banished from the colony forever, which says this thing that we saw in 1653 with Elizabeth Key was still going on. People were having relations, getting married and doing their thing. 1705, the first fully comprehensive slave code. It incorporated all the codes that we talked about earlier, certainly the one we just mentioned. This one though, if an African here purchased a white servant, which means they were purchasing them before this, and I told you that already. If an African purchased a white servant, he or she, the white servant, would be freed from service. No more. They also passed an anti-miscegenation law. Now, in 1857, the Dred Scott decision, the US Supreme Court, the court concluded that there were no rights that Blacks had that whites were bound to respect. And you can see the journey from 1619 to that time when slavery was in full bloom. But so Virginia is both the birthplace of American freedom and the birthplace of American slavery. Thank you.
Thank you, Randy. That was really fascinating. And now we're going to take a bit of a jump in time to hear from Dr. Sunny Rucker-Chang, and she's going to talk about how US civil rights methods to deconstruct the slavery that was constructed in Virginia, as discussed by Randy. They are using those methods to deconstruct segregation in Eastern Europe. Thank you.
So I'm going to share my screen here. Just a second. Is everyone seeing my Canva presentation? Perfect, perfect. Okay, so first of all, I would like to thank Tequila Brooks for the invitation, as well as the whole DC Lera team for setting this roundtable up. I feel very fortunate to be in such distinguished company. I am Dr. Sunny Rucker-Chang, and I am an associate professor at The Ohio State University in Slavic languages, Slavic and East European languages as cultures, as well as African American and African studies. Before I get started, though, I would like to begin with land acknowledgement. I am right now, as many of us are in the United States, in the state of Ohio, and I sit in the unceded homelands of indigenous Algonquin-speaking tribes, including the Delaware, Miami, and Shawnee. These people were dispossessed of their traditional lands by the doctrines of discovery and conquest. This country was founded on exclusions and erasures of many indigenous peoples, and it was made prosperous by stolen people. I sit here as a descendant of those stolen people on stolen and colonized land to recognize these twin dispossessions, one of land and another of personal identity, as the source of the attempted erasure of Native peoples and their cultures, as well as the source of anti-Blackness. So through my community work and scholarly research, I strive to locate and investigate systemic oppression in order to uproot and disrupt it. And this research, doing comparative and relational work on civil rights and Roma rights, is a part of that work. So I'm actually going to set a timer because I am a humanities scholar and I'm known to go over the time that is allotted to me. So in the short time that I have today, I am going to speak to you all about the environment of civil rights and European Roma and the lessons and warnings that have traveled by way of the United States through the US civil rights movement of the 1950s to Eastern Europe. And I guess I should actually back up and say that the work that I'm doing, or what I'm presenting here, comes from an article that I wrote called Challenging Americanism and Europeanism, African Americans and Roma in the American South and European Union South. But it also comes from my most recent book, Roma Rights and Civil Rights. So in the presentation today, I'm going to discuss my work on the subject, how I came to compare and relate the civil rights movement in the 1950s and 60s to the post-socialist period, primarily the post-socialist period in Central and Southeast Europe. And I stress here the post-socialist period because, as you will hear me say, there were Roma rights movements, Roma Incenti, and various other groups that are frequently determined to be or called Roma that were happening prior to the post-socialist period. But the post-socialist period becomes really important because it is a time period in which this unshakable, what we thought at the time was an unshakable ideology, was no more. And it presented this possibility for phenomenal change. And it actually happened in many different ways. But frequently the situation of Roma and Roma rights struggles, and also what has and continues to be called the Roma question, is frequently left out of the picture. So then I'll talk more about the Romani communities. I'll discuss a bit more about Romani rights and the history. And then I'll close briefly by discussing how US civil rights have had an effect on post-socialist Romani rights movements, and I'll offer some suggestions for maybe ways forward for solidarity. So why this comparison, right? I just said that frequently Roma and Romani communities are very much left out of this discussion of the post-socialist period. But owing primarily to racialized difference and perceived cultural distance. And again, I am a cultural studies scholar, so the work that I do is very much informed by cultural studies. Romani people are deemed outside of the confines of the dominant ethnic and cultural communities in which they live in. So complicating the situation for Roma is that the leaders of current and aspiring European Union states ironically deem them European, right, but not local, which then sets up this significant divide between whose they are, whose they're seen to be, and where they situate themselves. And therefore, European Union and not local policies and initiatives protect and safeguard them, rendering them effectively European wards in the eyes of the ethnic nations of the states that they live in. And therefore, a European collective, if not an issue. And again, this question of the Romani question, what does that mean for the ways that they live their lives? Ever-increasing linkages of Romani peoples to the European Union and complicated Eurosceptic populist narratives in the European Union South make it difficult, if not impossible, to view the Romani as part of the specific cultural nations in their countries, meaning the countries that they live in. By way of contrast, African Americans by a number of benchmarks have made great strides into American cultural inclusion, such that competing counter narratives of Americanism exist alongside dominant models that champion multiculturalism as key to American identity. However, African Americans remain outside of the dominant cultural American imaginary, both within and without the United States. So the question of who gets to be American, who gets to be European, who is defined as American, who is defined as European, is one that I see an intersecting point on, right? And that's where I sort of began this research. So this is an important point, as it helps to explain the failures of civil rights in the US context and a number of the failures in the Roma rights context as well. And it is for this reason that my co-author and I in this book combine both the legal and the cultural aspects, because I believe, and I take this position in my work, it's insufficient to discuss laws and their implementation without considering the context in which they are created and executed. So the big motivating question, and a lot of this is, do laws motivate culture, or does culture motivate laws? And it sort of moves back and forth depending on the situation that you're setting yourself in, as well as the time period. So in asking such a question, we recognize that the two are interdependent, and to understand the success or failure of any law, it is necessary to understand culture. As such, I'm addressing how culture, cultural norms, cultural practices, and history affect the implementation, success, and failure of any particular law. So who are the Roma? year after year, I question whether I need to continue to insert this question, but then I realized that I need to insert this question because a lot of times people have never even heard of the term Roma. I know in my classrooms, it's one that continues to come up. And the origins of Roma are an important piece of why they continue to be cast outside of a European cultural imaginary. And it's in part because they are a diasporic community with origins in India, similar to the way that African Americans are a diasporic community with origins outside of the United States as well. In the European case, however, I think it's really important to say that Roma are a diasporic community. However, it's important to not stress this difference so much because it is precisely this difference that makes Roma continue to be cast as outsiders. Whereas in the United States, we, in many ways, rightly or wrongly, see ourselves as being a nation of people from the outside, or people who've come from the outside by way of various migration patterns. In Europe, that is not the case. Europe does not see itself as a country, a migration country, even though maybe, and not maybe, but really this reality has changed. So other aspects of Roma is they are Europe's largest minority. And this is something that happened following the enlargement of the European Union in 2004 and 2007. The Roma are very much concentrated primarily in Eastern and Southeast Europe, and this is a Roma density map from 2007. It's a little, it has age obviously now, but there's still a lot of truth to this distribution. And the symbol here of the wheel is one that is a symbol of Romani communities, and the larger the wheel, the larger the distribution of the community there. So the fact that the largest communities are in Central and Southeast Europe gives us reason in our work to assert that a lot of the practical changes and a lot of the inclusion strategies that were coming and continue to come from Brussels, and not just from Brussels, but other NGO groups, are really motivated by this difference that is seen toward Roma on behalf of majority populations. And just a little bit of editorializing here. These images came from the 2020 uprising where Roma were protesting on behalf of BLM. And this here was an article from an online magazine, Kosovo 2.0, saying that Roma are a part of Black Lives Matter, which I wrote an article about discussing how the solidarities are formed among Roma and African Americans or Black Europeans as well. So there's that. The struggle for civil rights among Romani communities actually has a long history. And like I said, I primarily focus on post-socialist Eastern Europe, but the struggles for Roma rights and Roma equality actually have roots not too long after World War II, which then puts it in alignment with the US civil rights movement as well. Particularly in Germany, so German Roma and German Sinti, they were celebrating their 45th anniversary of their civil rights movement a few years ago when I was there. And then also you had a movement that is pretty well known in Europe and Sweden, primarily headed by Katarina Taikon, and her name is most closely associated with that movement. The image behind here is from 1971 for the National or the World Romani Congress, where Roma met in 1971 to create, and some of the outcomes of that were the creation of a flag, a creation of an anthem, and also this idea of Roma, right? A name and a community that they would give themselves rather than one that was coming from the outside. So this was just celebrated, the 50th anniversary of that was just celebrated in 2021, and there were all sorts of commemorations to mark that. However, it's important, I think, to discuss that history to just illustrate that the Romani rights movement did not just start in 1989 with the fall of the Berlin Wall, right? There was a movement and a ramp up. So, and I focus, like I said, on Central and Southeast Europe because the fall of communism, or primarily started with the fall of the Berlin Wall, and even earlier than that, reforms by Mikhail Gorbachev, of course, brought forward many challenges and changes, and the Romani question was a part of that. It has been said by many people from the region and through interviews that I've conducted and just general conversations with people, that racism against Roma and the type of racism that Roma faced was that of the daily banal type, right? That's more overt that you see on day-to-day basis or experience. But then there were also more structural types that had existed for generations. However, the end of state socialism ended censorship, and that racism that had been silenced ran rampant throughout society. Many Romani citizens found themselves in challenging situations, not surprisingly at all. Many lived on the fringes of society, were underskilled, undereducated, and what's important here is they were forgotten, many of them, by the systems that once supported them, right? Because if you think about state socialism, it's important to know that most of your basic needs were taken care of, right? And maybe in certain countries, and I don't want to get too much in the weeds here, certain countries had unemployment. Most of the socialist countries did not have it had no unemployment, and people were taken care of by the state, right? Whether or not it was at a high level is a matter for debate, right? But they were taken care of. So that's not to say that all Roma were a part of those left behind, but for a lot of people, they felt that their futures would be better served in Western countries. And so many of them left to go to Western Europe, and many of them actually went to Canada until the channels of immigration were cut short. So for those who looked to Europe, their path was uncertain, and many of them that were trying to go to Europe were very much unwanted by the countries that they were traveling to. So to understand what happened, right, following the movement of Roma to further west to Western Europe, and the laws then that the EU starts to produce, and not just EU, but other NGOs, to sort of these critical strategies of integration, I think it's useful. And in our work, we look to the principle of interest convergence. And interest convergence is this idea that has become pretty central to critical race theory, or one of the most important scholars, Derek Bell, of critical race theory, that says that much of what happened during the civil rights period was a combination, and I probably am talking to many lawyers who know this and legal scholars who know this very well, but in my world, it's pretty novel, that essentially the interests of those in power and the interests of the people who were fighting for civil rights converged. And therefore, that's a big part of the reason why we got the civil rights that we got, because, and Eastern Europe actually has a significant role to play in this, because the United States needed to look a lot better to Eastern Europe, and you couldn't be the champion of the free world if you were continuing to oppress your Black populations at home. So interest convergence helps to describe that phenomenon and explain in many ways, not uncontroversially, but why we were successful in some of our civil rights gains. Well, we argue then that we can look at interest convergence in the case with Roma. Why are we getting integration strategies? Why are we getting funding? Why are we getting all of these movements towards equality in Eastern Europe and the post-socialist countries? Is because there is a desire to not have so many Roma moving west, right? So this began, there was some advocacy work that was happening in the communist states in the 20s and 30s, but after the fall of communism, you really see this ramp up and this movement towards self-determination. And then you start to see a lot of human rights violations in the 1990s and the 2000s. So in that last decade of Roma rights, and I'm talking about when you're starting to see the post-socialist period, and I really need to hurry up, I'm running out of time here. The European Union implements something called Copenhagen criteria, which says that the states that want to be EU members have to achieve certain criteria or pass certain benchmarks in order to become members. And so among the requirements, and there were many, was a call for countries to guarantee human rights and protect their minority populations to ensure their ability to access quality education and ensure that their human rights were protected. And schooling is a really big part of this, as well as being educated in your mother tongue. Now, it's important to say that the same things were not happening in Western Europe. So there's very much a double standard that's being set here. It's also important that the introduction of these Copenhagen criteria in 1993 is happening at the same time the Yugoslav war is happening, showing that the real motivation for applying pressure on these Eastern countries to create an atmosphere of human rights protection is really motivated by something else, right? This is at least an argument that we're making here. So I'm going to just skip ahead a little bit here. So in 2004 and 2007, and again in 2013, with the broader expansion of the EU, Roma school integration and economic stagnation became well known and a pressing issue throughout Europe. And the thought was, if economic conditions could be improved, better work opportunities could be introduced, and there could be some way to guarantee better protections and opportunities for Romani communities in their own countries, they wouldn't leave. So what you start to see, I'm actually going to skip down here to the Roma integration strategies, is a decade of Roma inclusion, 2005 to 2015, which is a series of NGOs as well as government observer countries saying that these are the goals for Roma integration. I think it's really important that it's integration and not inclusion, because eventually you move to inclusion, but integration saying that there is one way to be, and this is the way that it needs to happen. And then you have, which in many ways is reflective of the civil rights movement as well, right? It's about integrating, it's not about inclusion and keeping space for everyone. Then you get to the National Roma Integration Strategies of 2020, where the decade of Roma inclusion is seen as failing and pretty unsuccessful. So they move to the NRIS of 2020 and they throw it back to the states. And they say, you know what, you figure it out. You create the language, you create the metrics, and we will support you if you're doing well. And this was considered to be a failure. So from the Roma inclusion, you get to NRIS, and now you're at this Roma Strategic Framework for Equality, Inclusion, and Participation, 2020 to 2030. So one of the arguments that we make in our work is that what you see in the United States by way of civil rights is these cycles, right? You see some progress and you have violence, you see some progress and you have violence, and we're now in one of those cycles, right? Well, because the situation with Romani communities is so relatively new, you can't see the cycles in the same way. But what these integration strategies are showing us is that perhaps we are also seeing cycles happening within the European Union and also just Europe more broadly, because a lot of the countries I work on are not EU members. But one of the things that I'm supposed to talk about is how civil rights had an impression or affected Roma rights movements. And what you see here is the role of litigation in school segregation, right? Which we know very well. So in other crowds, in Slavic and East European studies crowds, I have to introduce the litigation that happened in the United States. Well, this case in 2007, DH and others versus Czech Republic, is seen as really foundational to the litigious approach or the approach of litigation to ensure segregation, where the European Court of Human Rights said, absolutely, there's segregation that is happening and you all have to do something about it. So it was seen as a really important movement in terms of recognizing segregation and doing something about it. However, enforcement in European context is pretty weak, and there's not a lot that can happen. So what you start to see then is other cases for segregation that are coming. They're being successful, but there's little that's changing. So you have this one in 2008, you have this one in 2010, you have this one in 2013. And if you go to the European Roma Rights Center, which is actually a legal organization that was set up on the model of the NAACP Legal Defense Fund, you will see that there are just cases that keep coming through that are really challenging and pushing back on school segregation that's happening, because it continues to happen. There was a case in Serbia in the fall of last year where the parents were saying they don't want Roma in their kids' classrooms, period. And so the school had to respond to it. But this is a normal thing that happens, right? There's a book that was pretty recently written called Romophobia as the Last Possible Acceptable Form of Racism. And I want to end sort of there. I have another minute. So in there and saying that these laws are happening, these court cases are happening, and you can start to see victories, but the cultural aspects and the continued racism that is accepted within these societies renders a lot of the movement and a lot of the legal advancement moot in many ways, right? So what you also start to see, in the same way that it happened in the US civil rights, is the importance of civil society. You have a lot of civil society, many of it came out of the decade of Roma inclusion, in fact, and you also have a lot of critical theory and a lot of critical work that's being done academically around Romani studies. And these three pieces are coming together, and it's making a lot more movement, a lot more awareness of the struggle of Roma within Eastern European societies, particularly, but European societies more broadly. So I guess my goal here is that we can understand each other's struggles, we can contribute to them, and we can work in solidarity to learn from each other, right? These civil rights until pretty recently was always seen as a very successful movement, and in many ways it was. I wouldn't be speaking with you all if there were no successes, but there are also failures, right? And recognizing the failures that happen is a way forward for Romani rights and vice versa, but we have to learn from each other. So thank you so much.
I think we have,
so
oh, Skilla there?
Sunny, I'm here. A little technical difficulty, but thank you so much, Sunny. That was a really wonderful discussion of the intertwining between the Roma civil rights movement and the US civil rights movement going back years. Thank you. Now we're going to continue our movement through space, and we're going to hear from Khomotso Mufamadi of the University of Johannesburg in South Africa.
Thank you so much.
Hi, Khomotso.
Hi, Tequila. Good attempt at my name. I'm gonna kick off. I'm just gonna share my screen quickly. If I can actually find what I'm looking for. Just give me 1 second. I am failing myself. Here we go. Okay, I hope everyone can see that. Yeah, here we go. So the topic of my discussion, I call it major microaggressions, because what is a microaggression? So I say that because of the significant implications that microaggressions have on individuals. So I don't think they are micro at all. And really the focus is the not so subtle racism in post-apartheid South African workplaces in particular. And this is the scope of my discussion. I'm just going to talk a little bit about apartheid workplaces, what the duty of good faith in relation to racism is. And I'll talk about that using a number of cases, microaggressions and their effect on the workplace, and what my suggestions are on how we can address the situation, and what the law has done actually since I wrote my paper to adjust South African labor law to accommodate this reality. So in the South African post-apartheid South African the apartheid South African workplace, these are sort of key features of what was happening, what was the reality, not just on the ground, but what was actually legislated in some respects. Firstly, we had the racial division of labor. So unskilled work was reserved for Black people, and managerial posts were reserved for white people. I hate to say this, but this is actually not very different from our reality right now. Our latest statistics show that CEOs of companies in South Africa are about 75% white men still in 2022. So this reality hasn't changed much. Racial segregation of facilities, toilets, showers, canteens, and the differences in the nature of benefits, racial structure of power, white power or Black powerlessness that sort of characterizes what the reality was. And even junior white employees would have power over Black people. We used to call it baskap or bus boys. So there would be white employees who are junior who would have authority over Black employees, generally speaking, even if they are junior. And then you would have deputized whites. So they would give a little bit of power to one Black individual and call them boss. Boss means boss. And give this one Black person a little bit of authority over the rest of the Black people. But of course, the real authority rested with some white man. That was a common feature of South African workplaces, and the system of migrant labor, where the most arduous and precarious work was reserved for migrants. And here specifically, we're referring to mine work, which makes up a huge chunk of our economy even today. And mine work is largely reserved for migrants. I'm just going to talk briefly about the common law duty of good faith that is supposed to inform how employers ought to respond to racism in the workplace, and I'll discuss that through case law. In this first case, Durant and Ellerines, the modern contracts of employment include a reciprocal duty of good faith, which is broad and can include everything which good faith reasonably and equitably demands. So in essence, that is the idea that in an employment relationship, we all have this reciprocal duty of good faith, and that extends to how we interact from a racial perspective. It ought to inform how we interact from a racial perspective. So because of that duty of good faith, an employee who is guilty of racism ought to be disciplined or can be disciplined. The first code of good practice that I'll discuss another one later, relates to dismissal, and it speaks to progressive discipline. So for example, the idea is that if an employee is guilty, let's say, of racial misconduct, you ought to discipline them progressively. So ideally, it shouldn't be that they are dismissed for a first offense. They should be, educated and counseled and all of that, so that they improve on their racist behavior. But in reality, and it's probably a good thing, racist employees are usually dismissed if they are actually found guilty. In Leboeuf Platinum Mines, an employee whose actions and utterances are motivated by racism breaches his duty to respect his colleagues, and as such may be disciplined for such. I think that's pretty self-explanatory. And in Simmons, the court said that racial insults impact the workforce as a whole. So it's not the reason why it's so important to address incidents of racism is because it has an impact on the entire employment space and not just the employees implicated in the particular incident. In Erasmus, the court said that an employee may be dismissed if his presence in the business leads to disharmony. So that is one way that they characterized the outcome of racist behavior, disharmony. The court said that that is sort of an old doctrine in our law, that if you cause disharmony in the workplace, you ought to be or may be dismissed. In Jardine, the court said that incompatibility is the inability of an employee to work in harmony, either within the corporate culture or with colleagues. So again, the notion of harmony comes up, and it becomes central to the question of whether or not an employee should be dismissed. Crown Chicken's dismissal was appropriate because of the use of racial insults at work is anathema to sound industrial relations and a severe and degrading attack on the dignity of employees. And lastly, in Freedom Front versus South African Human Rights Commission, harm, as outlined in section 16 sub 2 of our constitution, should be read to include physical, psychological, and emotional harm. And I'll come back to that a little bit later and how that is now translated into our labor law, dealing specifically with harassment. Just to talk about subtle yet significant, I'm going to move a little bit more into the discussion around microaggressions. And this definition is quite a common definition for microaggressions, coming from Dr. Gerald Wing-Soo. And he says, microaggressions are the everyday verbal, nonverbal, and environmental slights, snubs, or insults, whether intentional or unintentional, which communicate hostile, derogatory, or negative messages to target persons based solely upon their marginalized group membership. So that is sort of the definition. I think that really informs a lot of the changes that have come up in our law. In this paper, Tamani and Rycroft also speak about fact versus perception. So when we're talking about microaggressions, I think that's the tension that always arises. In this case, South African Chemical Workers Union, the NCP Chlorochem, it was very interesting because the employee was not dismissed for racism. The employee was dismissed for making an accusation of racism. And it was perceived that the accusation was false because he could not prove it. So I think that is really the crux of where we are today in post-apartheid South Africa, is that racism has changed its face so much that it's difficult to demonstrate and to pinpoint. This is why we talk about microaggressions, because that is the shape racism has now taken. And now you're dealing with the reality of the tension between fact and perception. whether or not something actually did happen or did I simply perceive it. But anybody who's ever experienced a microaggression can tell you without being able to pinpoint, this is exactly what happened. More often than not, it's a feeling, but it's a feeling of almost knowing this is exactly what is happening to me. Something is wrong with it. How do I prove it? How do I show it? So some examples broadly of everyday racism that we see in our context, and in different, I think it's not a South African question. It's probably, well, it is a global phenomenon. Feeling like you're being set up for failure, social marginalization, being treated as though you don't exist, insults comments passed off as humor, the politics of names, that's very complex. This is not a snub, Tequila, but the politics around names is that it's so, in an African work context, the tension ought not to be there. Just as an interesting aside, I lived in the United States for a long time, and I was very used to my name being mispronounced. And when we moved to South Africa, I thought that won't happen. Of course not. I'm in my home, but it still happens every day, all the time. Despite the fact that we are the majority in the country, in our workplaces, we are not. And these politics really, really come out quite significantly. And you get given nicknames. Your name is too difficult, and people just change your name at will. An expectation to speak for on behalf of people of color, feeling isolated, misunderstood, misrecognized, misrepresented, and missing in action. You wonder how you can feel invisible and hyper visible at the same time. And just also speaking on about everyday racism, Ditch et al., what they say about it is research has shown that racism is not disappearing, and this is what I mentioned earlier. It's being replaced by less overt forms. Term, for example, modern racism, aversive racism, or ambivalent racism. These forms of racism allow individuals to hold racist views while buttressing such views with non-racially based rationales, beliefs, in opportunity and individual mobility, thus maintaining a view of themselves as non-prejudiced. I dealt with the case a few years ago. I'm also an attorney. A few years ago, where an individual, a white woman, posted on her social media images from apartheid South Africa of who we call the architect of apartheid, Hendrik Verwoerd. She posted photographs of this man on her social media around election times. And, you know, when she came before me, she said, you know, I'm not a racist at all. She was dismissed for racism because of this. And she said, I'm not a racist at all. It was a political climate at the time. We were dealing with elections, and she really did not see any problem with her behavior. So some of the issues that we deal with are people who, in and of themselves, do not believe themselves to be racist. And because they engage in this sort of subversive racism, they almost allow themselves permission. They allow themselves to believe that I'm not a racist. I'm just sharing on social media, no big deal. And because these people do not view themselves as racist, they're unlikely to engage in overt expressions of prejudice like racial slurs or discriminatory behaviors. So they're not going to do things that are in your face. And as much as there are cases where there are in our context, where individuals have overt acts of racism, many more unreported cases fly under the radar because they are these sort of subversive forms of racism. And another factor that this came out of our constitutional court judgments, another factor that would undermine the possibility of addressing racism would be a tendency to shift attention from racism to technicalities. So then we're talking again about the burden of proof. We're dealing with evidence, questions of evidence, whether or not you are able to demonstrate it. You might say, oh, you in a workplace, you might find a situation where someone says, I feel deeply uncomfortable with this or that or the other. And the seniors of the business say, yeah, but so-and-so is a really great guy. You can't really prove that he intended to be racist. And one of the great things about our changing law is that intention is becoming less and less important. I think people realize that it's really irrelevant in the circumstances. I want to skip this just for the sake of time, but it emanates from the same judgment and just it deals with the way our courts or our workplaces would often frame racist engagement in the workplace by sort of letting it slide because of technicalities of evidence or proof. And Chief Justice Mogoeng said, the logical consequence of all this gingerly or reasonable approach to racism is the entrenchment and emboldenment of racism that we now have to contend with so many years into our constitutional democracy. So because we're treating racism sort of with kid gloves and being sort of reasonable about it all the time, it's just being further and further entrenched. So how do we address this? So a couple of years ago, the legislature issued the Code of Good Practice on Harassment, and our codes of good practice are guidelines, but they are binding. So if you don't have policies in your workplace that assist you in relation to a particular issue, you need to follow the Code of Good Practice. So this is the Code of Good Practice that deals with harassment. Usually people speak about it in the context of sexual harassment, but it actually deals with all forms of harassment. So it's actually, it tells you that our legislature has actually been considering the way racism has shifted and changed, because when it outlines what race or what harassment may be or what it may amount to, it gives these really interesting examples. So there's physical, verbal, or psychological conduct, verbal bullying, hostile teasing, withholding work-related information, which might not appear to be racist, but I think we understand that in certain contexts, it definitely is. Ostracizing, intolerance of people's personal circumstances, passive aggressive or covert harassment, which is really what we're talking about now, gossip or jokes, sarcasm. That's actually in the Code of Good Practice, that sarcasm can constitute harassment in some contexts. Condescending eye contact, facial expression or gestures, deliberately causing embarrassment or insecurity, invisible treatment, social exclusion. And this all extends also to the online space, where we're seeing a lot of employees bullying one another in different contexts. So it's not just in the workplace. We know that it can extend to the online space. So to me, this has been a great evolution in our law, that the legislature actually realizes that racism or harassment of any form can be so covert, and it can, even amount to condescending eye contact in some situations, or sarcasm or jokes. But that's a reality for a lot of people. And just to touch briefly on notions of critical race theory, because to me, ultimately, our solutions are not in law primarily, or how we consider addressing these different types of racism. The solutions can't just be found in law, and Joel Mediri spends quite a lot of time writing about this. And he talks about the need to talk, think, write, and speak about race and make sense of its implications. I think one of the unfortunate features of the South African social context is because we are so traumatized by our racist past, there's almost a reluctance to engage about racism. I think people are exhausted. People don't want to talk about racism. So just the term racism comes up, or black, white comes up, people want to suppress it. And there's such an important need to engage about it and talk about it, because I believe it will minimize the incidence of racism in workplaces and in society as a whole. He talks about a broad critique of liberalism, how liberalism downplays racial intolerance as unusual, rare, and individual problem. So what you've got, and it's very common, is that very common in our context, is that you will have individuals who are singled out as racist monsters, and you ignore the systemic reality of racism that prevails in our country, not just in workplaces. Instead, you have one sort of devil that rises up and everybody crucifies them. And even people who hold covert racist views attack that individual to embolden the idea that they are not racist. They want to say that person, that monster is racist. Even when racist incidents happen generally in our society, it goes viral on social media. It becomes a huge big deal. and one person gets isolated as though racism isn't a systemic societal problem, it's that person's problem. And then we should consider the ways in which the structure of legal thought and prevailing legal culture will influence the content of law. And again, it comes back to evidence. Do our legal principles relating to evidence and the burden of proof really engage with the notion of covert racism? Isn't this something we need to consider? And then we ought to take a multiple disciplinary approach when we're considering these ideas, and share stories, share realities about what is actually happening in our day-to-day workplaces. I think we do this very often amongst Black people in our country, but it's not something that is happening across the board. And that is something that we need to shift. And lastly, just a quote from our former Chief Justice Mogoeng in the South African Revenue Service judgment, came out a few years ago. And he said that the duty to eradicate racism and its tendencies has become all the more apparent, essential, and urgent now. For this reason, nothing that threatens to take us back to our racist past should be glossed over, accommodated, or excused. Thank you, everyone.
Thank you, Counsel. That was a very interesting and enlightening presentation on racism in modern South Africa and how it ties to the apartheid era. I think it's interesting when you compare that laws are used both to construct racism and to deconstruct racism. So that was a very fascinating presentation. Thank you. Now we're going to move in space again to the modern day United States. And we're going to hear from Rebecca Dixon from the National Employment Law Project. Thank you. I look forward to hearing your remarks.
Thank you. Good afternoon, everyone. Or good morning. It's morning still. So let's just jump in. So when we think about the labor market and economy, we tend to think of equal opportunity for the United States, but that's actually not the case. Opportunity is quite segregated in this country. And our labor law has been key in enshrining and perpetuating this segregation. For example, 40% of jobs in this economy pay poverty level wages, and the burden of those bad jobs is uneven. It falls most heavily on women and workers of color. In fact, women make up 64% of the 40 lowest paying jobs, and discrimination accounts for 38% of the gender wage gap. For Black women, the intersection of their identities creates a double bind. The Blacker an occupation is, the lower the wages are. The more female dominated an occupation is, the more undervalued that work is, especially when it comes to care work. And there's a name for what I'm describing. It's called occupational segregation. And it means that persistently across time, people of color and women are shunted into low-paying, precarious, and often unsafe work. And occupational segregation's glass and concrete ceilings means that they stay there for decades, sometimes a lifetime. So if we're talking about past as prologue, history really sets the context for the present, and any effective policymaking must take into account historical inequities. So the Fair Labor Standards Act, which was a key wage floor passed in 1938, and it established a minimum wage, it outlawed child labor laws, and it established a regular work week by mandating overtime pay. And in its preamble, it really talked about wanting to substantially, to eliminate conditions that substantially curtailed workers' employment and earning power, so seeking to protect workers. However, a substantial weakness of this law was its coverage gaps, which excluded a large portion of the workforce. And why is that? So when this passed in 1938, the agrarian Southern political economy depended on the exploitation and subordination of Black labor. So the Southern states held the balance of power in Congress, and they were unified in their opposition to including Black people in new laws that guaranteed wages, rights, benefits, and protections. So as a result, Congress used the sectors of work that Black workers were concentrated in as a proxy for race. So some of these industries, farm labor, tipped work, domestic work. And this meant that these workers were excluded from the protections of the Fair Labor Standards Act. And so to break it down a little bit, that meant nearly half of all Black men, Mexican-American men, and Native American men and women, plus significant numbers of Asian workers were excluded. And here's where the political gets personal for me. This exclusion fell most heavily on Black women, excluding 90% of them because of their extreme concentration in farm and domestic work. Laws governing the right to organize, coverage by unemployment insurance, and access to Social Security also passed in the New Deal era and contained similar exclusions. So how does this history impact today's labor market? Particularly, I want to talk about how it impacts getting a job, keeping a job, being secure if you lose your job, and lastly, what types of jobs are broadly available to you. When it comes to the opportunity to get a job and move up in a job, race and gender discrimination play an important role in pay disparities between otherwise similar workers. Research finds that differences in education, occupation, and other easily measurable worker characteristics cannot fully explain why workers of color tend to earn less than white workers and why women typically earn less than men. A recent meta-analysis of hiring discrimination field experiments found that hiring discrimination against African Americans had not decreased in the past 25 years. Their results were durable even when you accounted for education, gender, occupational grouping, study method, and local labor market conditions. Today, we see many employers using algorithms and other technology-based methods to find workers, and some of this bakes in existing systems of discrimination. When it comes to keeping a job, the at-will employment doctrine is important, an important legacy of slavery that allows employers to basically fire workers in most states for any reason that's not illegal. And after the Civil War, employers, were largely in the railroad industry, had sought to prevent workers from organizing, particularly Black workers who were formerly enslaved. And so this at-will employment, so reserving their right to fire them for any reason, was key to being able to prevent them joining together collectively to press for their rights or better wages. So this was never necessarily turned into legislation, but it became entrenched in US law and judicial decisions across the decades. Today, most employers can fire anyone legally without warning or explanation. And this power imbalance forces workers to accept exploitative working conditions out of fear of losing their job. It also makes it difficult for workers to prove when they have been illegally fired or for discrimination or retaliation, or to get government agencies to enforce their rights. These circumstances, of course, disproportionately affect Black and Latinx workers who are more likely than white workers to have low-paying jobs and to express concern about retaliation for speaking out about unsafe or unfair working conditions. When it comes to economic security, when you lose a job, unemployment insurance is a key and pretty much only program for that in the United States. And although workers of color are more likely to be unemployed, they are less likely to receive unemployment benefits. And part of the reason for that is that states with the largest shares of unemployed Black workers tend to have the most restrictive rules. They also tend to have the lowest weekly benefit payments. So we have low rates of benefit receipt in the southern states and inadequate wages replacement rates when they actually do receive UI. One study found that unemployed Black workers were 24% less likely to receive unemployment benefits than their white counterparts. And this was a study that looked at the last 30 years. So coming towards a close, what kinds of jobs are workers able to get, workers of color, related to this history? So one of the key places is working in hospitality, and that brings in the tipped worker sub-minimum wage. So tipping in lieu of wages also is a vestige of slavery and post-slavery. When the hospitality sector's employers hired formerly enslaved Black folks and expected them to work for whatever was given to them. And so, in spite of workers organizing to get included in the Fair Labor Standards Act that we talked about earlier, they weren't included. Fast forward a little bit, employers are now required to pay tip workers at least a sub-minimum wage, but it's been frozen at $2.13 an hour for more than 30 years. As a result, lots of Black workers are dependent on the goodwill of patrons, and Black tip workers, women in particular, are at a greater disadvantage because they tend to earn less in tips than their white counterparts. For example, a Black woman making nearly $5 less per hour than a white man. So raising the minimum wage would help eliminate poverty wages and raise earnings for nearly a quarter of the workforce, about 32 million workers, which would be 1 in 3 Black workers, 1 in 4 Latinx workers, and 1 in 5 white workers. And if we eliminated the sub-minimum tipped wage, and workers got paid that wage plus tips on top, we could reduce the race gender wage gap in the restaurant industry by 35%. So the last piece to talk about here related to types of jobs is gig worker jobs and independent contractor. So beyond pay, labor law has also helped determine who is concentrated in precarious and contingent work. Today's app-based or gig work is frequently just dressed up to talk about it as a modern innovation or 21st century work, but this is really nothing new. So dating back to sharecropping all the way up to certain industries that have been for decades, where workers are being classified as independent contractors, things like home care, janitorial, trucking, those things are already for decades have been in the same boat. And Black and Latinx workers are overrepresented in gig work, and they are often, gig workers are wrongly classified as independent contractors, meaning that they work for themselves, but they really don't, rather than employees, which means that they don't get any other workplace protections and benefits like unemployment insurance, workers' comp, and then often don't have access to things like employer-sponsored health insurance. In closing, the passage of time is not going to fix this inequality. We've actually seen widening wage gaps and widening racial wealth gap. In this moment in the labor market where we're seeing this like great realignment or great resignation or whatever you want to call it, we really have to keep a sharp and sustained focus on fixing the economy for workers at the very bottom of the labor market. And this is key to shifting the economic paradigm for all working people. Thank you.
Thank you, Rebecca, for that excellent summary of what is going on in the current U.S. labor market and how I was kind of surprised that the statistics haven't really changed over the last 25 to 30 years. Maybe that's something we can discuss during the question and answer period. Now we're going to move back to Pamitsai Bamu, and she's going to provide us a commentary on all of our 4 excellent talks. And then we'll move into the Q&A. So if you have questions for our speakers, please put them in the chat box and I'll read them out and ask you to unmute yourself and ask your question. Thank you.
Thank you very much. It's a very, very difficult task, I think, to provide commentary on what were 4 extremely rich, detailed, and fascinating presentations. Just, you know, very, very mind-blowing sort of revelations on all fronts. So I want to thank and congratulate the presenters on keeping as close as possible to the time, but also illuminating on some very, very key developments and issues across time and across space in the United States. I don't know how much time do I have? Is it still 10 minutes? Because we're running behind a little bit, Tequila.
We're running behind a very little bit. So if you can keep it to like 5 to 7 minutes, and then we can open up for the audience. It's been a long period. We've learned a lot.
Yes, okay. So, I mean, I think some of the key issues that are coming up very importantly, and I'll just maybe talk to some of the themes that connect the pieces, is really how there's a long history and how law is instrumental in constructing and creating these inequalities, and how in different ways, whether it is that segregatory or discriminatory laws have been dismantled, or that more progressive, inclusionary, protective laws have been included, the law has been an important tool that has been used to reverse racism. We've talked about, I think it was Dr. Sunny Rakacheng that talked about the use of litigation, for example, as a tool. So using the law and using legal tools, it has been an important part of the construction and the deconstruction of these paradigms. And one of the things that is key, and I think it was Dr. Rebecca Dixon and Homotso that have spoken about this, is that things are not changing substantially anytime soon, whether at the micro level within the workplace, within the day-to-day relations and interactions, or when you look at the macro level, where we're looking at the labor force, the structure of the labor force, who is in which positions, who is in a vulnerable position. Many of these things have not changed over time, although we have had some progress. I think the idea that having the laws or dismantling the laws that create discrimination will undo all that, I think is very, very, it comes out clearly that it's not enough to just deal with the laws. And I think that intersects with the point that Dr. Sunny Rakacheng also spoke about, which is around culture and law, and how we can't look at law in isolation, but we have to look at the broader sort of context, and how the two are intertwined and how they feed into each other and that cycle. And I think one of the key questions that I'll be posing, I think, to the speakers would be, what do you see as our role as lawyers, many of us labor lawyers? Where do we come in and where does our role end? We talk about laws, we talk about litigation. We're in South Africa, you're in South Africa, Homotso, where there is a powerful piece of legislation that talks about some of the micro type of behavior that wouldn't necessarily be captured in many laws, So looking at very small things like sarcasm, eye rolling and things like that, but yet we're sitting in a situation where one has difficulty with the way their name is pronounced. Or I was in one of the universities where I was, and somebody met me, and I would get these funny looks. And at a certain stage, somebody said to me, "Oh, it's nice to know who you are. So you're an academic in the faculty. We've been wondering why this student is moving around and visiting the staff toilets, but it's because you're so young." And in my mind, I was thinking, it's because I'm so Black. And this is an unusual thing in this kind of an environment. And the difficulty of actually being able to say something, like what role can we play? What can we do? And what advice can we give to people that are in these kinds of situations? Because you don't want to be labeled as the angry Black person or the angry Black woman and so on. And that also touches on the issue of, I think Rebecca Dixon talked about this issue of intersectionality, I think, which is also very, very important, because we're not just talking about race. Often, our identities are bound up in so many dimensions, gender, our status as migrants and so on. And also looking at the type of work that we do, that also plays a role. So what advice would we give to people that are in this situation, who are on the receiving end, for one? Besides, go to litigate, challenge it, and so on. I think Homotso has spoken to some of those, but also this issue of what more can we do? Like, we can talk about law and the legal tools. Are we just supposed to say, okay, that's where our, bill ends? I think I'll stop there because there's so much that one could say, but thank you very, very much for these thought-provoking and stimulating inputs.
I thought you really captured a lot of the links between the different talks and presentations. So we're going to move on to the question and answer period. I guess first, before moving on to the questions we have in the chat box, let's start with those. First one is for one of the audience members, Maria Diamante, wanted to know how to register for the conference in Mauritius in March 2023. And we can answer that later. Oh, go ahead.
Okay, thank you very much. I'll post the link in here, and I'll also share the details with you, Tequila, maybe that you can share with the membership. But let me send the link right now in the chat. Thank you very much for your interest.
Okay, and then we have a question from board member Mindy Reiser for Randy McLaughlin. Mindy, are you still here?
Yes, I'm still here. This has been absolutely fascinating. Thank you all so much. Randy, I know you do many things, but you don't spend all your time doing historical research. But in terms of the growth of the slave codes, was there opposition voiced in the other colonies, and were communications made to the people in Virginia that this is really unacceptable? What kind of opposition was there?
Well, if you're asking about opposition from the ruling class, if you will, or the planter class, there was none. Remember, the first Africans came in 1619. The Mayflower landed in Plymouth Rock in 1620. So we were here long before the Pilgrims were here. So there was no opposition. What Virginia did was, Virginia was the template. The slave code that was adopted in 1705, that slave code was replicated all across the South. I mean, that's what they did. They learned from the Virginia experience. And remember, one of the main drivers of slavery and slave codes was fear of insurrection. We're not talking about January 6th. Fear of insurrections. And so when they saw what happened in Virginia in 1676, they recognized we can't have these workers living together, working together, interrelating with each other, running away together. No, no, no. We have to make sure the white worker feels empowered and the Black worker is debased. And that's what they did. So it was no opposition. Who would oppose? The white worker wasn't going to oppose it because he or she was being elevated and protected by the law. And the Black worker didn't really have any choices because by now they were slaves. But I want to answer Ms. Bamu's question, which is, what should we do? And you're right, I don't just do historical research, that's true. I'm a litigator, I am a civil rights lawyer. But what I'll say to you is that law without organizing is nothing. If you have, whenever I've been in a courtroom and there's nobody in the courtroom, I don't get the same kind of justice I get when the courtroom was packed with the community. Because frankly, unless the people themselves get directly involved through organizing, through unions, through mass actions, through sit-ins and protests, the law means nothing. The judges will ignore us. The Supreme Court, not this Supreme Court, but in the 60s, the Supreme Court adopted a lot of progressive approaches to civil rights law, not because they were all civil rights activists, but because the community was up in arms. So to finally answer your question, we shouldn't put this burden on the marginalized to fight back. We have to fight back, of course, but we need to have allies across the spectrum. And what we used to say is, if the oppression is an oppression based on color, then we've got a lot of allies. There are more people of color than there are people of non-color. So we gotta reach out. And not only people of color, as you said, someone said today, women are also being oppressed and marginalized. Reach out to your natural allies. And as I said to my class the other day, I'm not waiting for them to come after me. I'm gonna go and help you when they come after you. Because when they come after me, it's too late. So we have to get out there and organize, not just be lawyers, but be on the front lines.
Does anyone have any follow-up on that topic? I guess I'll ask a question. I have a question for Komozo about this idea of workplace harmony. Because I've seen in workplaces, and you see in cases, sometimes the people who are victimized are accused of disrupting workplace harmony when they complain. And I also wondered how that works when people stand up for themselves as members of unions. Are they accused of violating workplace harmony, or how does that concept work? I haven't heard of it.
I mean, thanks for the question, Tequila. It's exactly as you say, and it's very common for, I mean, the case that I cited earlier where an individual was dismissed because he made an accusation of racism. I mean, he is directly, you know, contributing to disharmony in the workplace. But I mean, you know, on a broader level, it's such a false notion. You know, what is the point of harmony if it's fake? And if everybody's just, and I mean, it assists the racist to have this concept of workplace harmony, and it assists the racist to know that all they have to do is play a particular role. All they have to do is keep the peace, or appear to keep the peace. That's all they have to do in the workplace. What they're doing behind the scenes, the types of policies they come up with, how they implement those policies, how they deal with hiring and firing, how they deal with the grievances of employees, all they need to do is create this appearance of harmony. So I think it really goes, or it assists the notion of the microaggression, it assists the entire thing for us to focus on an environment that has harmony. But yeah, it is not as commonly used a phrase in labor law, but it is something that is there in our jurisprudence.
Thank you. I'd like to open it up further to the audience to ask some more questions. Okay, I'll ask another question meanwhile. I know one thread that goes through all of your talks is this labor market exclusion. It sounds as though even in South African workplaces, Blacks are excluded, and so they're still a minority in many workplaces. And then you see exclusion of Roma from the labor market, and in the United States, you see a lot of exclusion for the labor market. And in Pamit Tsai's research on informal sector workers, it seems as though there's just a huge group of people who are not even allowed into the workplace in order to participate in society. And I'd like to hear more about this from all of you, how that impacts the workplace, this exclusion. And then after being excluded, being slotted into jobs that have no benefits or any status or even defined as jobs. I wondered if you'd like to comment on that, Rebecca.
Sure, Tequila. I think one of the things I'm finding is that even when people want to support pro-worker policies, there is this like not understanding what the history is of how we got here. And so then the solutions tend to go towards the individual. So how do we get the individual more training, more education, more whatever, right? That there's a deficiency with the individual. But what we do know is across time, Blacks and women have gotten more education, and the wage gap between, you know, Black women and white men is not getting narrower, no matter how much education. And so I think the fact that this history is not well known, that folks want to kind of gloss over it, it means that our solutions are not focused on being purposefully inclusive, and they're not focused on really like how do we dismantle the structural racism that's embedded in the labor market. And so then there's this, you know, all of this goes onto the individual. And in this country, the individual also believes it, right? People believe that they aren't successful because of themselves, and all of the systemic things that are going on get ignored. So I think that it's critical for everyone to know how we got here, and particularly the folks who are working to change it.
We have a comment from David, a comment question, and he comments, it's fascinating that movements have crossed national boundaries. Jim Crow was copied by the Nazis, and civil rights movements have borrowed remedies. So I guess I'd like from you, Sunny, on this question.
Yes, so I think you went out for a little bit, but I think you're just asking that I comment. So I think that it's really important to understand that the outsized role that American culture and institutions have globally. And because American culture and American institutions have such an outsized role, that it's not, it follows then that a lot of American remedies, a lot of American problems have traveled throughout the world, right? And actually, on another, thinking about it culturally, it's not just, right, civil rights movements. It's also sort of talking back to people who are in power as well. That comes as a part of this, right? So we have the legal remedies, and that's sort of, or the legal question, which is really what the focus here is. But there's also cultural things that I write about as well. So one of the things that I have been looking at is film. Have been looking at sort of music culture and how that also looks a lot like what has happened in the United States following the civil rights movement, sort of the speaking back and talking back and putting all these things in conversation with one another. And I should also say that frequently Americans are on the ground in these spaces, right? So they're also helping to usher in some of these changes and use the same systems and the same techniques in these other spaces as well, which also speaks to the outsized power of American culture and systems in the world, and particularly in Europe, I can say for my case.
And I guess one question I'd like to ask Randy and any of the other speakers, it seems as though the laws that constructed racism in Virginia, it was very easy for those to enter into effect and for them to change society drastically. But then when you look at the modern movements to the implementation of new laws, it takes time and it's not working, and it's still a huge struggle. I wonder if you have any thoughts on how that happens and why that might be.
Yes, I do. The General Assembly and the planter class, as I call them, in Virginia, they didn't have any opposition to what they wanted to do. There was no organizing. There was no political party opposing the legislation. There were no representations for African Americans or Africans then. Zero, zilch, nada. Whereas in the 60s, the same power structure was there, right? The same upper class, ruling class, however you want to define that group, they were in charge just like they were in 1619 up until 1705. The difference was, whereas in the earlier period, the people didn't have the ability, except for the Bacon's Rebellion, to fight back in an organized way. In the 60s, and not just the 60s, I want to start in the 1930s, when you talk about labor, that's when the unions came to the fore. That's when they were, at that point in time, before the National Labor Relations Act, it was illegal to form a union. It was a crime. So the ruling class was intent on suppressing workers' rights, but the workers at the same time were intent on expressing their rights. So it was that resistance that we didn't see in the 1600s that we saw in the 20th century. But there's another component to that, and we've talked about that, and that is America, United States is not an empire by itself. It's a world empire in a sense. And I really mean that word empire, not the way the Europeans had an empire, but we have an empire. No, we don't use military force unless we need to, and then we'll use it. But the American empire is founded on this notion of democracy and freedom. Well, you can't go around the world preaching democracy and freedom and you're shooting Black men in the back and strangling them. Doesn't look good. It's not a good look. And especially at a time when the other side of the coin, the communist empire, if you will, were literally touting to the Africans and the other folks in the world, you're going to follow the American model. Look what they do to Black people there. So we had to do, this is the intersectionality of, not intersectionality, but this is the convergence of American interest, corporate power structure interest, accommodating the interests of the workers. But it was begrudging. And as someone said, every step forward in progress is met with violence eventually. There's advancement and retraction. That's what we see. It's a push and a pull. As Hegel would say, it's a dialectic, it's a dialectical analysis. There's a thesis and counter-thesis. That's what happens. And through that in exchange, we do have a new thing that happens, and that's called change. We can have change. So that's what I think. It's a struggle, and we're still in a struggle. As they say in Angola, they used to say in Angola, a luta continua.
Oh, we all know we've just went through this this global issue after the riots and the murders in during the pandemic. I was wondering for the international audience members and speakers how that played out, how people viewed the United States, and how that impacted in other countries. Go ahead. Thank you, Sunny.
I have a lot to say, but I know that Homotso had their hand up, so I will defer and then respond after.
Okay, I wanted to say something a bit before that, but I'll also respond to that. And I just wanted to sort of touch on, you know, what Randy talked about being a push and a pull. I think a lot of what you can see in the South African context is our sort of compromise at the end of apartheid, where as much as Black people have been in the majority and have political power, economic power is still very much in the hands of white people in South Africa. And as a result, that is why you see this, you know, pervasive racism in our workplaces and management still being largely white, as even though we are in the majority and we actually hold political power, it's definitely not reflected in most workplaces outside of government workplaces. But that was just a comment in relation specifically to that. And in terms of how I think people have seen the United States, I mean, in South Africa, a lot, especially what Randy said about, you know, how are you a bastion of freedom when Black people are being shot in the back? And that's very much how South Africans, I believe, see American society, unfortunately. It is definitely, I think South Africans are very jaded in relation to how they see Americans, and they are no longer, we no longer have wool over our eyes in relation to American society. There's no longer this desire to move to the United States that was there in the 90s, because we actually, despite our challenges, feel safer here. That is actually the reality. So I think that is, I wouldn't be surprised if that's how a lot of people in the rest of the world view the United States. But it's always, you know, where there's good happening in the United States or progress happening in the United States, everybody says, but what is happening with Black people? What is the reality of Black people? How do Black people live?
Such important points. I just would like to add that this is absolutely the case. In the European context, I have plenty of friends and colleagues who say that they are not interested in coming to conferences, even in the United States, because they're afraid of gun violence at this particular point in time. To the question of Black Lives Matter movement, as well as the uprisings of 2020, this has had a particularly interesting role within the Romani communities and throughout, and also Black Europeans as well, I should say, in that there's been this move for solidarity, this move to recognize the importance and the contributions of Black Europeans from the Western side of Europe, and sort of coming and saying we're here too, and our thoughts, our actions, our positions in these countries matter, and you have to recognize us, right? So it's been very much a global Black movement, I would say, or at least a transatlantic Black movement, I can say that much. With Romani communities, like I alluded to this in my presentation, there is this thought that Roma are a part of Black Lives Matter. In other aspects of my research, I talk about expanding the frames of Blackness to incorporate Romani communities to sort of think about that more broadly. And then within Eastern Europe, more activist circles were saying, you stand in solidarity with Black American lives, but you don't recognize the issues that exist for Romani communities and you're most marginalized. So it was a time of reckoning within Europe itself, but it was also a time of reflection with certain communities to say, hold on, if you're going to stand in solidarity with Black Americans, you need to stand in solidarity too with your oppressed and marginalized communities.
That's interesting. We have another contribution from David. He says, as long as the political system is susceptible to conquest by oligarchies, civil rights advances are easily reversed. And I think that's, yeah, does anyone would like to comment on that?
Yeah, the classic example of that is what happened this summer. For decades, women believed they had a right in this country to reproductive choice. And all of a sudden, a group of religious zealots, and that's what I call them, sitting in the Supreme Court with a stroke of a pen, for the first time in American legal history, took a right away. I've never heard of a case in US history where the court gave a right or recognized a constitutional right, and then less than 50 years later, took it away. But here's the thing, which they didn't realize, maybe they did. That decision has awakened women and progressives who support reproductive rights in a way that nothing else has. We've been asleep since Roe v. Wade. We thought we all had this right, nothing worth fighting about. Oh, let the right to life folks over there yell and scream. Nothing's gonna change. Well, guess what, folks? Things have changed. Now women are being forced to have babies by the law, literally forced to have a child. So, as I said earlier, if you only depend on the law to save you, you'll never be saved. I depend on the people to save me with the law together.
Oh, we have another question from Mindy. Mindy, can you unmute yourself?
Let me try. Okay, again, this is fascinating. I wish we had more time. And the question would take a long time to answer, but going back to South Africa, which is such a fascinating and tragic part of the world, in terms of some of the South African white legal community, I'm wondering what roles they are playing in trying to redress some of the economic imbalances, if their voices are heard, if they are trying to talk to fellow economic titans and see what they can do to redress things.
Thanks for that question, Mindy. I mean, historically, white progressives have played a role in the struggle against apartheid, but also the emergence of the trade union movement in South Africa. The law firm that I worked for a number of years, Cheadle Thompson Haysom, was actually they authored so much of the labor relations legislation. And they did that also through the courts, and they litigated on behalf of Black people for free. And we have a number of NGOs that still do that type of work. But what we've also seen is that even within those social justice spaces, there's racism. A few years ago, there was actually an entire movement by Black people working in the social justice space to say, actually, it does not make sense that Black people are only beneficiaries of these organizations, but we don't run them in a country like ours. And at that point, a few CEOs of the social justice organizations relinquished their posts, and they appointed a bunch of Black people But I think that the racism still comes from the funders. And who are the funders? The corporates. And they are ultimately in charge of what is happening also in the social justice space. So I would say that white lawyers alongside Black lawyers are litigating. They are organizing, they are there. But often they don't spend a lot of time looking inward to say, actually, how are we contributing to racism in our workplaces, but also in our society? There is this patriarchal, there's a word that I'm actually looking for, but we have saviors. That's the word I wanted. We have a lot of saviors who are centering themselves, that are centering themselves a lot at the head of social justice spaces and a lot at the social justice firms, even in the most progressive spaces, in academic spaces. That is such a painful reality, if I'm very honest.
Thank you.
So we're getting to a couple of minutes before our time. So I'd like to give all of our speakers a chance to make a short closing statement. And then if David is ready, he will close our session. And I personally am very grateful that you all said yes. This was very fascinating. I have learned so much, and I know our audience has as well. Thank you. Thank you for taking the time.
I can go first and be brief. Appreciate the opportunity to participate. This was great. And just, a lot of these statistics are depressing and sad, but we have made progress over time, and we do know what to do, and we know what works. And we just need to, as Randy said, make sure that there's people in organizing to go along with the policy and nerdy stuff too. So just wanted to echo what he said and say that we can't give up and we have to keep pushing.
I'd just like to add and challenge all of the scholars here to become scholar activists and get involved and write the scholarship, but also do public facing scholarship as well and be a part, be active in your scholarship and engagement. That's my challenge I offer. And then also just to be aware of global struggles for equality.
I just want to say thank you for the opportunity. This has been really exciting and I've learned so much. I actually first wrote this paper in my first draft was in 2016. So I was shocked that somebody had dug it up. But I'm really, really glad that it is revived. And I'm hoping that Pamit Zayas assists in sort of reviving that conversation on the continent, kickstarting that again, because it's not over, we're not done. There's a lot of work. Thanks so much, everyone.
I guess maybe I'm last. So I just want to mention that I really, really appreciated being here today, and I thank you all for this. This is my second time being in the presence of South African lawyers and hearing about their struggles. The first time was when I actually was in South Africa. I came to, it was a South African Legal Defense Fund, as I recall, and they invited me to come to share with the lawyers in South Africa how we African Americans had used our laws to change and fight back against racism. And I was just, honestly, I almost stayed in South Africa. I was so impressed. It was just so, someone said it's depressing. No. South Africa is a land of freedom and just the joy that I saw among the Africans when I was there. It was just an amazing thing. It was like, to me, it was like being back in 1776 when the American Revolution happened. That was a revolution y'all had. And you use weapons, you use media, you use people, but you won your fight. And it's still a struggle, and the struggle continues. But thank you all for sharing what's been going on since then in South Africa. And with the Roma, I'm aware of the Roma issue, but not to the level that you explained to us today. And I really, really appreciate it. Same thing with the labor numbers. Numbers are scary. I'm not a data guy, but I think it's helpful to know that that's just the tip of the iceberg, that really what matters, the numbers are helpful to give you data, but it's what we do with the numbers that's equally important.
Thanks.
Thank you once again. I think we should continue the conversation and bring people from elsewhere. So I'll be following up with you, Tequila, just with a special invitation for us to include a plenary session on this, I think, in our next conference in March. I think it will be very, very fruitful for us to have this discussion further. Thank you so much.
Thank you. And there were other experts from Latin America. I can give you more names. So David, I think it's time for us to close.
Oh, time to close. I'm in a remote station now, so there might be some extraneous noise. Forgive me for that. I wanted to thank all the panelists who did a tremendous job. It's been a very exciting event, very detailed, very informative, very rich. I have to thank Tequila for organizing this event and for bringing worlds together. She put a great deal of work into it, a tremendous project. Thank you to Tequila as well. Thank you to Ben Kreider and to Andrea Cuba Sanchez, who did our social media. Thanks to the entire board, and especially to Emily Smith and Bernadette Tiemann at National Lera. This obviously is a collective project, and it is a lot of fun as well as a lot of work. So I appreciate all those who contributed. We'll be in touch with you and you with us, I hope. So I hope to see you. Our next event is next Thursday at Georgetown on the Memphis sanitation worker strike. Look at the DC Lera website, dclera.org. Look at leraweb.org for national organization. And there will be many more events to come, so keep in touch. Thank you very much. So I guess we can close out and go home and have lunch. Ready for that?
Yes.
Okay.
Thank you.
Thank you. Thank you very much. Thank you, Tequila, again. Thank you, everybody.
Thank you, David. Thank you, everybody.
Thank
Bye-bye.
you.
Bye-bye. Nice to meet you all.
Bye.
Oh, you're
Thank
muted.
Yeah, thank you, Bernadette and Emily. It's good to see you. See you in the
Absolutely.
real world sometime.
Yes,
Yes,
great to
thank
see you too. David, did you start the recording or did Emily? I can't stop it. It's not giving me the option to.
Oh, no, I didn't set it.
You didn't set it. Okay.
So Emily must have.
Emily must have. Okay.
It'll
I think she
record
just,
the.
I think she
it'll
just
record-
grabbed the phone, so she'll be right back on.
Okay. See you later. Thanks.
All right. Thank you.
Talk about. Anything we need to address or?
I don't think so. I think we're all good.
Okay. An email. Bye.